Hello, everyone. This is Doug Eisenberg, and I'm very excited to be talking today with someone who has played a really significant role in the development of domain name disputes, someone who actually wrote only the second decision that was ever published under the UDRP, the Uniform Domain Name Dispute Resolution Policy. And it was a decision that is certainly among what most must be the most frequently cited decisions ever published. And this is someone I'm very proud to have as a colleague because we both serve as domain name panelists for multiple UDRP and other service providers. He has a tremendous reputation among those of us who engage in domain name dispute services for a living, but perhaps he's not so well known to the larger community, which is why really I'm honored to talk with him today about a number of topics, including the early days of the UDRP, some of his very important decisions, what he thinks about the current status and future of the domain name dispute process, and hopefully very much more. So let me begin by introducing Professor Andrew Christie. So Professor Christie was appointed the Foundation Chair of Intellectual Property at Melbourne Law School in 2002, having held academic appointments at the University of Cambridge, Duke University, and the University of Toronto. He is admitted to legal practice in both Australia and England, and he has worked in major law firms in both Melbourne and London. He is a trained arbitrator and mediator, and he has accepted appointments to resolve more than 350 domain name and other IP-related disputes from the WIPO, Arbitration and Mediation Center, Resolution Institute, the Asian Domain Name Dispute Resolution Center, and the ICC International Center for ADR. And he's also the author of a very important document called the UDRP Overview, which really provides an overview of the Australian domain name dispute process. So, Andrew, welcome.
Thank you, Doug.
So really, I want to talk with you mostly about the first of those 350 decisions that you wrote, a case that's pretty well known, Telra versus Nuclear Marshmallows, which established the passive holding doctrine under the UDRP, and that was more than 24 years ago in the year 2000. But before we start talking about that case, I really want to talk about how you came to be a domain name panelist, one of the very first domain name panelists, before anyone really knew how significantly important that role would become, something that you and I and our other colleagues from around the world take very seriously. So how did that come about?
Well, look, in the usual way of things, totally through sort of accident, coincidence, etc. It happened that the person I call the architect of the UDRP, Dr. Francis Gurry, who ultimately became a well-regarded Director General of WIPO, but who had been working for WIPO for 15, 20 years before that, got me a little bit involved. And I think that was because Francis had actually taught me as a law student at the University of Melbourne way back in the last century, in the very early 1980s. I hadn't kept up with Francis until really the early 1990s, when I started having certain involvements with WIPO. And because he was a fellow Australian, I'd catch up when I was visiting in Geneva. And then when he started designing the UDRP, he shared some thoughts he had with me, and I probably gave him absolutely nothing useful to contribute back. But by the time he came to realize that the UDRP would actually be implemented, he would need a panel of people, and kindly thought that I would have sufficient qualities to be on the panel, and I delightedly accepted the invitation to be on the panel and confidently expected I would have no work. And as it happened, I had the second case, third filed case, the second decided case, and the first that had a lot of substance to it. So there you go. That's the connection, really.
Great. And obviously it's led to a lot of important work, as I said, that you've done through the years. With that background, that's great. Let's talk about that first decision that you wrote, which was, as I said, I think only the second decision ever published. I did speak with our former colleague Scott Donahue about the very first UDRP decision that was ever published. My intention is not to interview every domain name panelist about every case that has ever been published. There are far too many of them. But you've written some of the most important, and the one that we're talking about, the Telra versus Nuclear Marshmallows case, an interesting name, of course, and you had something to say about the identity of the registrant in that case. But that was a dispute that was filed by Telstra, which I believe at the time and maybe still is the largest telecommunications provider in Australia, where you are, which I suppose may explain why the case was also assigned to you. And the registrant of the domain name Nuclear Marshmallows was, I think, an entity that it's unclear whether it actually was an entity or simply an alias for a cyber squatter who had registered the domain name Telstra.org. And Telstra, the complainant in that case, the telecommunications company, had a pretty large portfolio of trademark registrations for Telstra at that time and had been in business for quite a while. So tell us what happened, maybe some of the other facts in the Telstra case, the important facts, and then we'll talk about why your decision is so important.
Yeah, thanks. And it's interesting, being the first decision, but being 24 years ago, is a tendency to either remember nothing about it or everything. Because it was the first decision, I do remember quite a lot about it. The complainant wasn't just the biggest telecommunications provider in Australia. It was at that time the largest publicly listed company, so they had the greatest capitalisation. It had previously been a government-owned entity that had operated under, most recently, the name Telecom Australia. It was privatised, created its new brand Telstra, and it was a hugely well-known brand and trademark. In those days, when you got an invitation to be a panelist, that came by email, which was great. So it said, would you, be a panelist in this case? Do you have a conflict? I didn't have a conflict with Telstra, hadn't been a client that I'd worked with in a previous life. Nuclear Marshmallows meant nothing to me, so not conflicted. And I thought, oh, this might be slightly interesting because it's a .org GTLD, and up until then, Scott's case was .com, and we thought most of them be .com. So I said yes. This is last century. The case file was couriered, and from Geneva to Australia took a week. So I had 2 weeks to write my decision from acceptance, but only 1 week from actually reading the case file because I had to wait for the papers to come.
Yeah,
But
now,
when
so
they
and
came,
interestingly, there's been a rule change, fortunately, in the years since. So the UDRP, the policy itself has never changed, but the original rules, I think, referred to hard copies, and so that's why parties were required to submit their complaints and their responses in hard copy format. And fortunately, that rule was changed a few years later. But that's just a procedural issue. So back to the exciting part.
well, but an important procedural change is because for about 8 or 10 years, everyone had to wait for their bundle of huge papers to turn up with the courier. And in my case, that gave me a week to write the decision. And when I got the case file, and I have to say the complainant's case was very well and fully argued. And so remember, for all the complainants at that stage, this was their first go under the policy as well. Some complaints were very poorly written, others were excellently written because everyone's trying to find, how much detail does this fast, quick, cheap policy require.
And
Complaint.
I'll just interject. 24 years later, unfortunately, I think you and I and our colleagues who serve as domain name panelists can say the same thing. We still see complaints and responses that are very well written, and we still see complaints and responses that are very poorly written and researched.
We do indeed. That's right. And as humans, that can make a difference. You can be sometimes rather aggrieved when a complainant hasn't really done enough. On the other hand, you have to be neutral and maybe sometimes help them by issuing a procedural order saying, well, would you really like to tell me about X, Y, and Z? Anyway, that was not one of those cases. This was a well-written complaint, and retrospectively, I know it was because I've seen many others. But it immediately became clear to me the interesting bit was not that it was a .org, because I thought, oh, maybe the complainant, the respondent's going to be making some commentary. Maybe it's something to do with non-commercial activity using .org. Maybe that'd be an interesting issue. The interesting issue was the respondent was doing nothing, absolutely nothing. Nuclear Marshmallows, made up name, but not a registered business name, not a company name, not a person's name. Various misleading or false details provided by the respondent. So it was a classic case of the respondent not wanting to show who they really were. But as I work through the policy, as everyone does, you start with the first requirement, which has 2 limbs, the second requirement, third requirement. The first requirement, 2 limbs, pretty straightforward. Telstra.org, confusingly similar to Telstra. And of course, the complainant had that, many trademark registrations of Telstra. rights, legitimate interest, pretty straightforward. This respondent wasn't using it, wasn't, didn't have any basis for saying, oh, I'm called Telstra, or I have a, something or other car called a Telstra or whatever. So none of that. So you get the third one, registered in bad faith, go, yeah, that's pretty clear because they've given false details. There's no basis for this. They haven't made any case out. Get to the next bit, and used in bad faith. And I go, well, yeah, well, actually, I don't know. What are they doing? Absolutely nothing. Absolutely nothing. And this is when I realized I better give some serious thought to this, because I had to work out in my own head what the consequence of that was. But I did also sense that if the policy was not able to apply to this sort of scenario, then it was not going to be able to apply to a vast number of these scenarios, because a sensible cyber squatter would simply register and not do anything.
Right.
Not
And in those
policy.
early days of cyber squatting, there were a lot of cases. I mean, in the very early cases, the cyber squatters were registering exact matches. And Telstra.org was an exact match, but a lot of exactmatches.com, and trying to sell the domain name to the rightful trademark owner. There were a lot of pornography websites associated with some of those early registrations. And there was counterfeiting, and there was other bad activity that would sort of be apparent from looking at the website itself. But you're saying in this case, in the Telstra case, there was no website at telstra.org.
No, the domain name didn't resolve anywhere. There was no website, no evidence had been used as an email address, and it was just literally nothing. And there'd been, the complainant couldn't make any sense that the respondent was holding this as a sort of Damocles over the complainant's head, because there was just silence. It didn't know who the respondent was. So I thought, well, it'll be interesting to see how the policy actually deals with this, because it might be that this newly created policy is not going to apply to a vast amount of cyber squatting that will follow, which is a cyber squatter will say, well, I'll register but do nothing, and the policy can't touch me, and then maybe the complainant will have to come and acquire the domain name that way. Anyway, as I thought about it, I looked at the way some of the examples or instances of bad faith registration and use were described in the policy, and I noted that a number of those.
And let me just jump just to pause for those who aren't familiar. So what we're talking about is what's commonly referred to as the bad faith element of the UDRP, which, as you said, itself kind of has these two limbs. That element says the domain name has been registered and is being used in bad faith. So it's sort of one phrase, but you recognized and said early on that it's sort of a two-part test. Is that correct?
Yeah, well, that's how it read to me. Pretty clearly, there were two issues going on here. One is there needed to be registration in bad faith, and two, there needed to be use in bad faith. And in fact, I'd had a bit of familiarity with the history that led about the design and the implementation of the policy, and that was clearly the case. If you looked at the WIPO report that led to the UDRP being what it was, it's pretty clear that ICANN had rejected the idea that it should be either registered in bad faith or used in bad faith, and had intentionally gone with registered and used in bad faith. That's a policy decision it made, but it didn't answer the question, well, what does it mean to be used in bad faith? And when I looked at the non-exhaustive instances specified in paragraph 4B of the policy of what is evidence of registration and use in bad faith, I observed that a number of them didn't actually require any actual use, and it was said to be nevertheless evidence of registration and use in bad faith. So things like you registered it for a particular purpose in order to prevent the trademark owner from reflecting their mark in the domain name. That didn't say and then did something with it. And there was a couple of these other ones like that as well. Registered for the purpose primarily disrupting the business of the trademark owner. In fact, only one of them talked about a positive action, which was the 4B4, which said you've intentionally attempted to attract the commercial gain users to a location on the web by creating confusion. So I thought, well, the policy says you can have evidence of registration and use in bad faith, even though there is no actual use. So it seemed to me that it wasn't me making it up. The policy was quite clear that you didn't need a positive action to definitively to have bad faith use. So then I thought, well, what would be bad faith use without a positive action? And the fact that you don't have any right to the domain name, you yourself are hiding your identity. There's no conceivable use that I could think of, I think objectively, that anyone could say, oh, I could use Telstra.org in good faith because of all the fact that it's a direct match, etc., to a hugely well-known mark. I concluded that that was a holding of the domain name which was in bad faith. And so holding is actually a form of use. You hold it. That's using it. You're using it by removing it from somebody else's ability to use it. And it could be that you are waiting for them to come along and buy you out, even though you yourself haven't approached them or done the usual thing of putting it, redirecting it to a porn site or whatever. So that's how I saw the policy. I thought it was clear the policy allowed inaction in certain situations to be bad faith use. That was the case in this case. I found that, and as it happened, that approach appeared to be one that other panelists also agreed with and have followed ever since.
Yes, exactly. Now, not only did they agree with it early on, but they're still agreeing with it. We are still agreeing with it 24 years later. And it's become and I think you use this phrase in the decision itself, passive holding. So that is really the doctrine. I mean, it's now called the passive holding doctrine, which is what your decision in the Telstra versus nuclear marshmallows case established. So let me just ask to clarify, because I've heard the passive holding doctrine referred to sort of in two different ways. Some people say that the passive holding of a domain name does not prevent a finding of bad faith use. And I've heard others say that passive holding of a domain name is, under the circumstances that you discuss in the decision, and I want to talk about them in a little more detail than you just did a minute ago, that the passive holding itself actually constitutes bad faith. So which is it?
Well, if I've understood the dichotomy that others are drawing, I think it's the latter. I mean, what it's saying, but it's in some respects, it's the two parts of the logic. Merely doing it's passive means not acting positively, but holding means you are the holder, the registrant of the domain name, and you have it. The passive means, but you're doing nothing with it. That doesn't preclude a finding of registration using bad faith, but you have to find it. Now, then it follows that there can be such a finding if the circumstances surrounding this passive holding indicate that the holding is in bad faith. So I suppose it's the former plus the latter, if you know what I mean.
Yeah, no, that is interesting. And so let's talk about the factors that you put into the Telstra versus nuclear marshmallows decision. You talked about them briefly a minute ago, but there are five factors, and I'm actually going to just take a minute because I want to read what you actually wrote. So these were the factors that you considered in the Telstra versus nuclear marshmallows case when evaluating passive holding issue and whether it constituted bad faith. First, you said that the complainant's trademark has a strong reputation and is widely known, in that case, as evidenced by its substantial use in Australia and in other countries. Number two, the respondent has provided no evidence, because there was no response, I believe, whatsoever, of any actual or contemplated good faith use by it of the domain name. Number three, you referred to the fact that the respondent has taken active steps to conceal its true identity by operating under a name that is not a registered business name. That's the nuclear marshmallows name. Number four, you said that the respondent has actively provided and failed to correct false contact details, which is in breach of the registration agreement. And then number five, you said, taking into account all of the above, it is not possible to conceive of any plausible, actual, or contemplated active use of the domain name by the respondent that would not be illegitimate, such as by being a passing off, an infringement of consumer protection legislation, or an infringement of the complainant's rights under trademark law. So what a great test that you outlined. And I think a lot of panelists still evaluate all of those factors in cases that involve passive holding. Do they all still apply equally today? Are there other factors that, if you were writing the decision today, you would add in addition to those five?
Not if I was writing that decision, because I think they're the only five that were relevant for that one. And I wasn't trying to be like the US Supreme Court and lay down a principle for all time for every other panelist to follow. I was doing what we were supposed to do, which is to decide the case before one, using principles that others are going to have to use, but deciding it on the facts that were relevant to me. But as you read through those five, and it was interesting to hear them again, they're all illustrating that this registrant, and who hadn't responded, but you have to think, well, okay, registrant hasn't responded, but I have to think about, nevertheless, I have to make sure the complainant's done their job of satisfying on the balance of probabilities all the requirements for a remedy. So you're sort of testing out as if you were, what could the respondent possibly say here, even though they haven't? And the answer was, well, given all the things that were objectively identified, as you read out, you couldn't conceive of this respondent nevertheless not having bad faith as their motivation for all their actions, both the registration and the passive holding. It was clearly what they were doing. They weren't a good faith actor. And the danger is, of course, in the future, they might put it to bad faith use. But even at the very moment now, blocking Telstra out of, a domain name that reads straight onto its trademark with all those other factors, it just wasn't the case that this was not also bad faith use through this passive holding in those circumstances of the domain name.
And not all five of those factors necessarily need to exist in every case of passive holding. And I don't think that's what you said. You just simply said those were present in that case. Is that correct?
Well, that's what I said, and I agree with you that I wouldn't be holding you or me or anyone else to the requirement to have to find all such five factors. Firstly, there may be other factors that also have that effect of persuading the panelists that this is a bad faith registration use. There may be less than those factors, but they nevertheless persuade the panelists to that effect. So the way I think about it is, what good faith use could this registrant ever conceivably use? And when there's none, you have to think, well, it's pretty likely that the point of this registration is to keep the domain name from the complainant, and that's a holding which seems to be in bad faith. So I think the short answer is, look at the factors and see if they point in the way I've just said. In this case, they did.
Right. And interesting on one of those factors, the concealing the true identity. And you talked about that here and also in the decision, whether Nuclear Marshmallows was a fictitious name, something that has changed a lot over the past 24 years is the use of privacy services and proxy services, and even the redaction of registrant data thanks to the European Union's GDPR. So is that particular factor perhaps less relevant today, or not?
Well, I think there's a distinction to be drawn there. I mean, a registrant might have very good reasons to want to hide their identity through a privacy service. That per se, I think, doesn't equal a bad faith actor. But when people give false details, and in this case, they hadn't used a privacy service, but had actively sought to hide, not through a privacy service, but by making up a name that connected to no legal entity, and then the contact details were wrong. That seems to me indicative of bad faith action. Why would you do that if you're a good faith actor? And I think that's different from somebody who might choose to use a privacy service. So per se, use of a privacy service doesn't seem to me to equal a bad faith actor, but somebody who did what the party in this case did, it seems to support the likelihood that they are a bad faith actor.
Then let me ask you one other question about a point that you did mention several minutes ago, when you said that there was no website to be found. You also, I think, said, at least in this conversation, although I'm not sure it's in the decision, I'm happy to be corrected, that there was no email usage of the domain name. So phishing is a very popular activity among some cyber squatters these days, and has been for a number of years. I don't think phishing was quite so popular. Maybe that's not the right word. Not as prevalent in the year 2000. But regardless, whether a domain name is used in connection with email is not possible to determine by looking to see whether or not there is a website associated with it. So in some ways, um, I guess my question is, um, how do you determine that a domain name is actually not being used anyway? Do you ever know that a domain name is not actively being used?
Well, you probably can never know that to the nth degree, but I mean, things like if there aren't MX records set for the domain name, then it's not going to be able to be used for as an email address. I do acknowledge that in 2000, I hadn't heard the word phishing in 2000. Someone else might have, but I don't think phishing was either happening or described that way or even thought of in 2000. Took a few more years into the 21st century before that was the case, and so when I mentioned that, it wasn't like, oh, and an argument about no use of the email address was made. I just made that point because nowadays we do recognize that what can be a positive use of a domain name and a positive use in bad faith is not just resolving to an online location. It could be, and I have had many cases like you have of actual use for an email address and then precisely to impersonate, to acquire details that are going to be put to fraudulent use. Not in 2000, but in 2024, certainly a lot of that.
So let me ask, maybe you can't remember exactly what you were thinking in the year 2000, but nobody really knew then how significant this issue of cyber squatting was going to become. Obviously, it was significant enough to draft the UDRP in the first place, and a number of other domain name dispute policies for various country codes or CCTLDs have come along through the years, including, of course, the .au that you're intimately familiar with. Um, but I think there were a lot of folks who thought in those early years, this issue will be resolved kind of quickly, and instead, not only does the issue of cyber squatting and domain name disputes still exist 24 years later, but it's a larger issue than it has ever been. Um, it, any idea if you could have envisioned that 24 years ago?
I can say positively that I couldn't have envisaged it, and to that matter, I wasn't even turning my mind to it. With this case, I was just worried about doing a reasonably good job. But prior to that, so when I'd been sort of just thinking and observing how this UDRP was being designed and implemented and about to start operating, um, I sort of thought this is a pretty cool idea, actually. And I now would say this is an unbelievably fortuitously and very insightfully designed process. And I give, and I don't think inappropriately, I give all credit to that to Francis Gurry. Um, it has removed the need for any trademark owner to go to a national court with all the difficulties that raises, like jurisdiction and in fact who is the party and how do I serve them, and getting a remedy enforced, cost, time, etc. All gone. We'd had some cases, as you know, in that sort of mid to late 1990s in domestic courts. In the UK, I think it was the BTV 1 in a million case, and there was Dennis Toppin being sued in the US. And the outcomes were okay, but the cost of the time to get them were horrendous. So I don't know if everyone knew that we were going to have up to, now, whatever it is, 10,000 disputes filed a year then, but I think they knew that even a small number needed a non-national, fast, low cost, and appropriate or effective remedy. And that's what the UDRP gave then and still does. It's amazing. I mean, it's unchanged. So the rules like can you file documents electronically have changed, but the principles, if you want to treat that as sort of like an equivalent of an enactment, the legislative provisions are completely unchanged. And it's doing a very effective job. There are people who will, on both sides of the coin, the trademark owners and the domain name registrants, who will dispute aspects about the policy, could be improved one way or the other. But the reality is, I mean, it's a fantastically designed system that can deal with, whatever it is now, up 80, 90, has dealt with 80, 90,000 decisions over 20 plus years, and in CCTLDs, and effectively and quickly, and largely recognised to be done fairly. Pretty good system.
Well, thank you for those thoughts. Thank you for your very important decisions through the years. And as I said earlier on, I'll include links to all the decisions that we've been talking about. But Andrew Christie, Professor Christie, thank you very much for being here today.
Thank you, Doug. I've really appreciated the chance to chat with you.